Earlier today, the Supreme Court decided it will hear Nick Hines' case. It seems Mr. Hine was pulled over for a broken taillight, and the police officer who pulled him over subsequently found cocaine in his car. Now, here's the thing. It's not illegal to drive in North Carolina with a busted taillight. It is to drive around with cocaine. But a busted taillight is not illegal in North Carolina, as long as the other one works. So the case centers around whether the officer's mistaken interpretation of the law renders the search and seizure of the drugs thereafter in his vehicle unconstitutional. North Carolina Supreme Court didn't think so. It determined that the officer's slight misunderstanding of the law was within the reasonableness clause of the search and seizure outlined in the Fourth Amendment. Well, after winding its way through the legal system, the case now goes to the highest court. So what's at stake? Shane Krauser is the director of the American Academy for Constitutional Education and a professor of constitutional law and criminal law. He now joins me in tonight's Q&A. Shane, so we all learned, and I don't think just those of us who went to law school, that ignorance of the law is not a defense. Now, that's usually in reference to the criminal defendant. Just because you didn't know you were breaking a law doesn't absolve you of guilt in breaking that law. But here we have it in reverse. If an officer is ignorant of the law, does that then deem any search after that unconstitutional? What do you think? Must they be aware of the law?
Well, I know the North Carolina Supreme Court believes that mistake of the law can be used as a basis for reasonable suspicion. The irony of this case is, just as you just mentioned, Will, is that ignorance of the law for the citizenry is no defense, but ignorance of the law from the perspective of the government is a defense. And I think what we're going to see is the U.S. Supreme Court is ultimately going to have to make some critical decisions here. But if you're looking at just the basis of the Fourth Amendment, what it's designed to protect against is ultimately ensuring that the government plays by the rules. And here you had a situation where I think it's rather clear the government didn't play by the rules. The individual in this particular case had done nothing wrong. He did not violate the law. And nevertheless, we see that the result long term is that he had drugs in the car. And I think when you get involved in that emotional the emotional appeal to this case, you tend to look the other way and say, well, we'll let the government slide here.
The North Carolina Supreme Court seems to be creating kind of an honest mistake exception here for the officer, right? Like, if you really thought you were exercising a law that exists, but it doesn't, then we'll absolve you of every misdeed you indulge in afterwards. But if we did that, if we create this honest mistake type of exception, what kind of Pandora's box could that potentially open? It seems like any officer then could invoke that for any illegal search.
It would be absolutely significant if we went down this road. The idea behind the Due Process Clause of the Fifth and 14th Amendment is the idea that the individual has a right to be put on notice as to what is specifically forbidden by law. And here, when you inject this sort of subjective or vague analysis from the perspective of the law enforcement officers, this is a serious Pandora's box that you begin to open up. Law enforcement now has unbridled discretion. We can sort of make up the things as we go. We can make up the facts and our interpretation of the law as we go. This is incredibly dangerous, and my hope is that the U.S. Supreme Court makes the right decision, although I'm not incredibly hopeful, to be quite frank.
Well, that was my next question for you. Where do you think the Supreme Court would land on this decision? It's been a pretty law enforcement-friendly administration for quite some time. Guys like Justice Scalia, Justice Alito, they find themselves siding with law enforcement quite often. What do you think in this case?
I think that they're going to side with the North Carolina Supreme Court. I think they're going to side with law enforcement. And the reason why I say that is it's based on a Supreme Court case back in 2011, the Davis case, where the Supreme Court made a very, very similar decision, said, under these circumstances, government was truly acting in good faith given their interpretation of what appellate courts had already said about the law. I think they're going to take that line of reasoning and inject it into this particular case. And sadly, I think they come down on the side of the government here, which really is tragic.
All right, Shane, we appreciate your time tonight.
Thank you.